I'm saying it to you. Make you feel good too.
Oh, you don't feel good?
No, I feel good when he says good morning.
Oh.
Like I'm on time still. All right. Good afternoon. This is case D388292, Dodds versus Dodds. Set today on a status check. My understanding is the parties have reached an impasse. Counsel, kindly your appearances for the record.
I'll say good morning. Amber Robinson, bar number 10731, on behalf of plaintiff Eric Dodds, who's present.
Welcome.
And Judge Frank Tony, bar 5804, here with Mom.
Welcome. If parties will, Dad remain standing, Mom, please stand. Raise your right hand, Madam Clerk will swear you in. I have a couple ideas.
Raise your right hand, please. You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Has anything broken loose since you talked to Han? So still impasse?
Still in path.
Still in passage.
Okay, so
Just to update the court, Judge, Mom is continuing on with her counseling. And
good. I was going to ask that.
Yep.
And she's with Bree or with who?
She's with
She went to the.
Melissa Adams.
Okay. So, what I was going to do, obviously, is set a counter call and evidentiary hearing. But Amber, do you still want to do that deputy's video depo, or do you want to just go with the stipulation to have that person testify by video?
Probably just have him appear by video.
That's fine with me. We just have to have that arranged a week in advance through IT.
Okay.
And then do you have a stipulation on the child support arrears or the health insurance? Because if not, I just need Dad to get his health insurance breakout information, and first I need defendant to supplement her affidavit from November with proof of income or unemployment or SSD or whatever income she's been getting from August 2015 to date. So August 2015 to date, whatever income she's received, proof of that supplemented, serve it on plaintiff, then he can do a schedule of arrears from August 2015 of all of his health insurance, dependent health care premium breakout, and anything else he thinks that she is owed based on what she files. Because she's going to owe child support arrears back to that time.
Right, and the order has not changed. I was looking for the specific date of the last order, but Frank and I have gone over this a couple of different times.
When you say the order, I put on the record at the hearing in August 20th, I said,
Correct.
Changing custody.
Correct.
The order wasn't filed until September 30th.
That's the one I'm trying to find, but I'm not finding it within the orders I'm pulling up. Where it sets her child support at $472.83.
Well, that was actually from the order before that. It was all that.
But I don't know that she stayed the same
With that, but I think
money.
going all the way back to when everything was filed again, I think we do have a pending motion, so we'd go back to the filing of that motion.
Right. Which would have been prior to that?
Well,
Which motion are we talking about?
It would have been still August 2015. So that's what I'm.
No, that's when you made the court order, because we were talking about Kayla, and then we were talking about the kids, and we had switched custody.
Right.
And so we set what Jen's child support should be for the minor children. So the issue we've had with the child support office is they didn't feel that order was written clearly enough, because it kind of said Eric's child support will be X amount till X date.
Okay.
Per child. So really, we just need to go back to that order, and that's how I've drafted the schedule of arrears I've already sent them, is
Okay.
what that child's. So we're not undoing all of that, and there's no motion to undo any of that.
Okay.
There was no motion to set aside that order.
Well, I'm just trying to figure out how we get to something that I can. Those were issues that I left for you guys to do in the minutes. There's still things that were hanging out there as part of what needed to be done in your settlement.
I've provided counsel a schedule of arrears on medical and unreimbursed. I think that's all in one schedule of arrears. And then I've provided a schedule of arrears on child support that includes interest and penalties. I believe my numbers are correct because I'm going directly from this court's order.
Okay.
And what Mr. Tody told me was...
But has she been working that whole time at the same job?
Yes.
Okay, I didn't know that.
She's self-employed.
Oh, I didn't know if she was unemployed at any of those times or not.
And what Mr. Tody told me was just that Mom thinks child support is off.
Is what?
Off.
The numbers, the amount of arrears is that we're not on the same page yet with regard to what monies are owed for child support.
Okay.
So, in addition to, we will need to talk about arrears as per time of evidentiary. Now, with regard to medical insurance, just so I'm clear, counsel provided me a copy of Dad's, I believe this is his wife's insurance through Teachers Health Trust, and she, of course, is no charge, but for subscriber plus family, it's $220 a month.
It's $220 per paycheck.
Oh, per paycheck. I'm sorry.
So I took that number, I divided it by 4 because she's no
Is that
charge.
less than 5% of his gross monthly? Because if it's not, that's high.
Well, so what I did was take that number, $220 per paycheck, so $440 a month, divided that number by 4 because there's
Right,
2 kids plus,
that makes it more.
3 children plus Eric, so that's 4.
Right.
Divided that by 4 and then multiplied it by 2 to get the number of 220. So I would say I'm pretty accurate on the health arrears too. And what has happened here in this case, Your Honor's been on it since the very beginning, is every single time we've come to settlement negotiations, my client has waived child support and medical arrears and all of that. He's done waiving things. Now we're at actual numbers since that 2015 order. I just don't think Mom wants to pay.
Actually, the order was in place in 2014, and she was paying the difference.
It's a 2014 order?
Because there was an order, Your Honor, that you put in place, I believe, 2014, and I was paying for Kayla, and she was paying for the boys, and the difference between that amounted to about $35 a month, which the defendant had no issues paying at that time. And then in 2015, when I came, when Kayla was emancipated, then I know that was the order in 2015 of August to take me off of having to pay Kayla, so then it was just all the defendant being obligated to pay going forward.
$38.72.
Yeah, that's what it was before then, and then in August 2015, then my obligations to pay for Kayla were done, so it was just the total of the health insurance and whatever she was already, I think it was 400 something that she was already obligated to pay. It was just she wasn't paying that because the difference was I had some that I had to owe for Michaela. So it goes back to that order really is where I think maybe some of the confusion might be on their side.
That Dad maintains health insurance for the minor children. They'll begin equally divide the premium with proof of that. And Mom's share was going to be $180. That was offset from the child support.
Right.
And it was $38.72 per month for the remainder of her share.
Yeah, Your Honor, it's the August 21st, 2014 order, and it's on page 2.
I see it.
Where we line out what child support should be. Eric pointing that way and then Jen pointing this way. So her amount was $478.66. So child support has never changed since that date. Right. It's just we need to figure out the arrears, which I've done a schedule of arrears, and she doesn't want to agree to.
I didn't know that happened. Has that been filed, or you just exchanged it?
I just exchanged it.
'Cause I don't.
I'll put it on file.
I kind of looked at everything, and I was trying to figure out, well, what do I need to tell these guys so that we can get our ducks in a row and just go straight to trial? Because next month it'll be a year that we've been kind of trailing this thing.
Yeah.
That's a long time. I don't want it to do that anymore. I want to be closing this thing if we can. So ultimately, I wanted that done, and then we had Mom getting a therapist, which you say she has done, and I wanted her to get a letter from her not to violate her privilege, indicating whether she's been compliant with her treatment sessions and medication, indicating whether there's any risk to the children for reunification to proceed. The letter would not be filed, it would be in camera. If there's a problem, counsel could request telephonic rather than filing another motion. And then since then, we've just had status checks.
Correct, because we were all under the impression that we'd be able to work out how the reunification would occur,
Right.
along with the other financial issues, but unfortunately, we just not have been able to get there, Judge.
So can you tell me the sticking point, or you don't feel comfortable telling me that?
We're fine telling you. I'm fine, right?
Absolutely.
So what we had discussed in 2 different meetings was reunification with Ponzo for Nixon, and what we had proposed, and to keep costs down for Jennifer, because she's going to be the one bearing the sole expense, is do Ethan separately. And what we had proposed were graduated visitations for Ethan. What they would like is this reunification specialist to handle both children. We don't think that that's necessary. And now that we are getting into high school for Nixon, he'll be starting in August, and he'll be playing sports. Jennifer lives in Summerlin. My client lives in Old Henderson.
That's so far apart.
If we're going to be looking at a reunification specialist, Ponzo is located over by Red Rock Casino. We're no longer open to Ponzo. We're open to a reunification specialist, but to have to come up there a couple of different times a week when he's in high school and in sports is just not going to be
But
feasible.
does he drive himself? Can he just drive himself?
He's 14.
Yeah.
Oh,
13 still, but
I'm
14 next.
thinking.
Maybe Kayla.
Oh, because she's old. Okay.
And Judge, our sticking point towards that end was we thought that both kids should be with the reunification specialist, and the schedule and the graduations, if any, or anything of that nature, should be at the disposal of the therapist. The therapist is
Yeah,
saying,
why wouldn't the therapist decide how the reunification should go? Why would you guys think that you should decide that before a therapist should decide that?
Well, on Nixon, we were open to that because Nixon is the one that needs a reunification specialist. We just thought a graduated schedule for Ethan.
Could just be put in place
Yeah.
right away? Or
Yes, Your Honor. And what we had proposed is starting at supervised visitations at Donna's house, graduating up to regular, normal visitation that she once enjoyed. So our proposal outlines 4 different phases.
It seems more cost effective too.
And it just seems more cost effective.
And you didn't want to do that, Mom?
we're happy with the graduation schedule, number 1, and number 2, Judge, Mom wants to avoid Donna's house with the child.
Yeah, Donna's house is kind of. I'm not a big fan. I mean, I've never even been in there, but I just know that you can't eat in there. You can't. I mean, it's an institutionalized setting. Is there anybody that you guys trust that you could use for a supervisor? Or any way or any place? Who?
No, I don't know, Your Honor, but I was just, that was one of the things where I kind of, suggested to Amber to maybe suggest to them if they can come up with someone that we can all
She's
maybe
nodding. She's saying yeah.
agree to. But, I mean, it should be a disinterested third party, I would think.
Or someone. It just needs to be someone that everyone trusts.
Yeah,
Right.
it doesn't
Like the
have to be-
child, you both parents.
Right.
That there's a comfortable person.
That's what Jackie
Jackie?
I mean, I haven't talked with her in a few years. I'd certainly want to talk with her. She used to work with me, and she left not on the most favorable of terms. So it would be a conversation we could have. I don't know that we need to figure the person out here, Your Honor, but we could certainly,
I think it would be
entertain
much better if it was outside of an institutionalized setting.
Yeah.
And I mean, Mom, you would not be against it if it was outside of Donna's house with someone, an adult that you guys could agree on. And then, are you against the tiered phases if
Yes, Judge, they were, well, not to get too far into the
details
but they were rather, it was rather limited
and lengthy?
and lengthy. It seemed like it's
Usually tiered phases shouldn't be more than 3 or 4 weeks at the longest for each phase, and even shorter if they're older kids.
Well, let's say this went all the way to trial. Would that be a similar order that the court would give? Is that a specialist to handle both children?
Normally what I would do is I would defer to the therapist, but when I put a tiered schedule in place, it's usually 2 or 3 weeks doing, just the warming up thing, whether it's 2 or 3 hours or whatever, depending on the age of the kids. And then I would maybe do 4 weeks of something a little more substantial, and then, probably 3 to 4 weeks of like a 10-hour thing. Probably get to the like 2 or 3 hours, then 6 hours, then 10 hours, and then where's your schedule? That would have 3 tiers and it would be over. Because if it needs more than that, it needs a therapist. And you're talking about just doing something on your own with the child and mom, correct?
Right.
So that would be all I would require, and should be over in about 3 months. Go ahead.
Well, I was just going to say, Your Honor, I mean, we met in October at Mr. Tody's office, and I kind of felt like we were all going down a path, and then it was just dead time for a few months, and there was not a lot. And then, I mean, even up until the end of last week, I thought we were heading in a direction of settling, and then kind of come to find out, through my attorney, that it's just, there's these impasses there. So all this time passes by and there's not really any movement. We talk about things and everyone seems to forget what's talked about in the meeting, and then now it's 4 months after the last meeting, and here
Let's
we
just
are.
set a schedule right now for what you're going to do with Ethan, and then get Nixon in with a therapist, a reunification therapist. But I mean, if it's going to be about where this place is, someone's going to have to drive no matter what. I mean, because you're on both sides of town. It's going to be a problem no matter what. So
I was just thinking, with Nixon having been through the most of the children and him having dealt with things, that I don't want to pull him out of things that he thoroughly enjoys to do, to drive for an hour across town to go do something that I'll be as supportive as I can. But, the previous time with Ponzo, he wasn't very...
there's not very many males on our list.
Well, not only that, Judge, and despite
You want a male.
plaintiff's comments, the child does have a relationship with Ponzo.
Right, that's the thing.
It was like 2.5 years ago, though, Your Honor.
Yeah,
I mean, it's died out.
It was 2.5 and it was brief.
It's not a stranger.
No, but it's like starting over. So the point would be, if we're going to start over, we might as well start over and not have to drag him out of practices and things like that are keeping him very focused. I mean, he's getting A's and B's in school. He's a great student. Both boys are. So,
Are you against the reunification for Nixon?
for Nixon, no. I think that I'm just being very honest with the court, Your Honor. It will be a difficult thing, and I will have to support it 150%. But I don't know.
Well, it doesn't have to be when he's doing something else.
Right.
It can be set according to his convenience.
Okay, and I totally would appreciate that for his sake, Your Honor.
Yeah. I mean, it doesn't have to be interrupting his life like that.
And it doesn't have to be a male. I'm perfectly fine with a female handling it as well.
Well, it needs to be however it will make it comfortable for him.
Right.
If he liked Nick, then I think he should be with Nick. If he doesn't like Nick, who did he like better? Bree's
Don't-
going to be more expensive.
Well, I think
She's
I
got a
think he
PS
was just.
PS.
I don't think it was anything against Nick. I think it was just a situation in general. It was so close to the time when everything happened last time. I just don't think he was open.
Well, with all due
much.
respect, Judge, I think it's more of a matter that plaintiff isn't the biggest fan of Mr. Ponzo as compared to the child. I don't think there was an issue one way or another with the child.
Do you think if Ethan is reunifying, he's going to have a little bit of a break in his own feelings too? Systematically. I mean, when the system changes, people change.
I think that Ethan, unlike Nixon, Ethan tends to be a little bit more manipulated and put in the middle by the defendant historically. So I think the fear there would be that if he's pushed right into these unsupervised visits, she just hasn't had a history of showing she's willing to co-parent or do anything like that. So here we are thrusting the younger one right into, her care again when, who knows, we don't know where her health is at, where any of these things are at. So it's just kind of one of those situations. No, I mean, I guess I was looking at the Ponzo thing, or whoever it was with Ethan, is like, if she supposedly can't afford to pay for Ponzo for one child, how is she going to then have a separate session with Ethan and be able to pay for that all of a sudden? Just seems like a very expensive proposition when he charges $3.50 an hour. And to counter what the defendant's attorney, Mr. Tody, said, I'm 100% in support of reunification. That's why I just said I was.
Just use your own mental health insurance then. I mean, you're paying through the nose for that stuff.
Yeah.
Might as well get, just for your copay, stipulate to use your insurance, don't use a court order for it, and then have somebody be, the child's therapist. The identified client would be the child, and bring mom in as an adjunct, and whoever else needs to be identified as an adjunct.
And Judge, just for clarification, we obviously believe that Nixon would benefit from the therapeutic reunification. Not so much Ethan, but we didn't like the arrangement that they were giving us forth, so we just basically said, why don't we just do both children in therapeutic reunification, figuring that the doctor would, or the therapist would release Ethan and change Ethan's schedule a lot faster than what was being proposed. If we're not saying that Ethan absolutely has to go through therapeutic reunification, what we're saying is that the reunification schedule that was being proposed by plaintiff was rather punitive. So with the comments made by Your Honor, either we can sit here and we can schedule something now and start going with that. That would be most beneficial. We don't necessarily believe that Ethan has to be involved in therapeutic reunification. Far from it.
Or, you could start it, and if it seems like he needs it, he can be added on to the same counselor or another one in the group. Who's your mental health provider on your insurance? Is it like HBI or?
Honestly, Your Honor, I don't know. I'd have to look at that and see. What I did after the meeting that the four of us had in October was I called and I interviewed and actually had a very good conversation with Mr. Ponzo. Called a couple of other ones to try and do some interviews. One of them wasn't taking on new clients. So as far as the reunification therapist goes, I mean, it was, at the time when I thought we had more time, Ponzo was not a bad option. But now we're 4 months later, we've heard nothing back, from them. So it's like, I mean, I know he's saying they didn't like it because it was too punitive, but we heard nothing back to counter anything. It was just kind of in limbo for 4 months. So, so I don't know who. I'm sorry, I don't know who the mental health providers are. I'd have to do some research and find out, which I'm more than willing to do to try and further this thing.
You can just give it to mom. Give her your provider list. Let her call some of these places and say, look, the children are your identified clients and they're on this provider list, and I'm going to be doing reunification counseling with my children. And do you do that sort of thing with this age group? And she'll call some people until she finds somebody, unless you want to be the person who does that.
I have less time to be able to do that, Your Honor. So, no, I would. That's fine if she wants to do it. And
Yeah.
it's public information. It's Teachers Health Trust.
Yeah, and we can
It's out
put
there.
that job on Jennifer.
Are you willing to do that, Mom?
What I would say, though, obviously, she still has not paid any child support or towards health insurance. So we need money.
So that needs to happen. The arrears stipulation needs to happen. So why don't we, rather than setting a trial, set like in 2 weeks a status check on getting this stipulation done on the arrears. If you can't get it done with like a couple days prior to the hearing, I want you to file the stuff so I can look at it. And know what mom's child support is going forward with days for payment. And are you making payments now? It's through the DA, right?
Yeah, I mean, but the amount of the payment, we're talking $2, $5, $3. That's what she's paying. And I don't even know what the payments are for because there's health insurance, arrears, current child
Why is
support.
it so little?
I give a good big payment because the numbers are not correct on what I owe. So until I can know exactly what I owe and what I can afford. I mean, my income is not that high.
Because what?
My income is not that high.
Are you not working full time?
I do work full time, but I still take care of our daughter, and
I don't believe there's a pending motion on file, though, to adjust mom's child support. There hasn't been. So if she's looking to undo that order from August 2014, something should have been done a long time ago.
That was before I came on, Judge. I was under the impression that was part of the motion that was filed. I'll have to go back and look.
Yeah, check and see because maybe she has relief coming to her. But did you earn something more when it was set and you earn less now? It's the same amount?
yeah, I think, well, what I remember is when I came to court for custody of our daughter, I wasn't prepared to discuss the boys. It was more just for custody of Michaela. And unfortunately, I didn't have an attorney with me. And so it got set on a number that I have no idea, and I provided proof of my taxes. So when you just do the calculations of the 25%, not what was put in the court paper.
Your Honor, where they're getting confused, and with all due respect to Mr. Toady, what Your Honor told us to have a discussion on was because we brought up the issue that the district attorney was having, because they felt that the way the August 2014 order was written was confusing, and then when we took him off in 2015, they thought that order was confusing. So basically, what your directions to us were is to clarify that order, but it wasn't to undo the child support that had already been properly set. It was just to basically do a new order that would work for the DA, but not re-look and revamp child support.
Okay. Well, I don't think they're confusing.
And I don't think it's confusing either. I think it's pretty clear what Mom
There's the right
owes.
versus Osborne.
No. It's you set 18% for Eric to Kayla, and then 25% from Mom to Eric for the two boys. So the only change that happened was Kayla emancipated, and we got that order taking Eric off of child support towards Mom. Her child support never changed, and she never came in and did a motion to modify the child support that was set.
Got it.
And Your Honor, what the district attorney told me was that 2015 order says I'm not obligated to pay child support, but it wasn't clear that she had to pay child support. And I said, well, look at the previous order because it doesn't change that, and they didn't care. But yet, you know, and so that's the confusing part for them. And I've tried to argue it with them, and they don't want to hear it.
And so when we brought that issue before Your Honor, then arrears had already started to accrue for like the last year. So your direction to us was figure out what the arrears are, submit a new order. So that's what I've done, and I've provided the schedule of arrearages. So I don't see my numbers being off at all.
Okay. Okay, so can I have like a 2-week hearing maybe, and even if it has to be at 8:30 or something, so that they can work on those things, work on the financial issues, work on a tiered schedule like I described. Like for the first 4, I would say it should be a couple times a week for 2 to 3 hours, and then the second 4 weeks, I would say it should be 6 hours, 2 to 3 times a week, 2 times a week, and then after that, I would say 10 hours probably, 2 times a week, and then set a couple days a week. I mean, that's what you want to do, right? Ultimately, end up with a couple nights and a couple days.
Well, back to the original.
Yeah, back to the original
What was
order.
It was Saturday morning to Monday morning.
So hopefully you can get to that. So maybe you can move it toward those days, use those days, as your days to tier it up, so that you're not using weekdays that much.
I was trying to find my pen when you were kind of outlining what
I'm sorry.
what would
Okay,
be appropriate.
I'll do it again. So, what I was thinking more something a little different, but now that I know what you're trying to work toward, let me think. Saturday, Sunday, Monday. I would adapt it to the child. So if the child is saying, this is too much for me, I need to go slower, I would slow it down. If the child's saying, I think this is ridiculous, why can't I just start going to Mom's, I would speed it up. So basically I would first do 3 hours on each Saturday and Sunday, and I would have a different activity for each one, like have it be one day be the morning, one day be the evening, whatever you want to do. Like figure out, are you going to do brunch one day, or take them to a movie one day, or to an activity, play a game one day, a board game. You need to have something that you're doing. Movies probably aren't that good of an idea. Forget the movie, because you're staring at something and you're not really looking at each other. So eating, like a restaurant or a game or something where you're looking at each other and talking, is really good. Time of day is good if you change it so you can have different meals, like a brunch or a dinner or something like that. Or cooking together is good. A project together, like does he like to do anything like paint or construct a hobby thing? Or you could go to the, what's that place, Michael's, and buy a kit and make something. I don't know if he likes to do that stuff. Maybe he doesn't. I don't know. Or read a book together. That's another thing it's fun to do. Kids like to hear their parents read. But, I mean, it's up to you and him how to choose the activity. And you could ask him what he would like to do after the first couple times. But you got to think of things, Maybe do a puzzle. I mean, it might be goober for him, these kinds of ideas that I'm coming up with You're going to have to think of what he likes to do. But you can't just sit and drone out and watch TV or look at your phones. No, that's not going to work.
Your Honor, her prior schedule was every other weekend, so when we're talking about graduated visitation, what are you envisioning?
Oh, it was every other weekend?
Yes.
Originally, it was, you had ordered in the original order every Friday after school, dropping off Monday morning to avoid any conflict with
We're only looking at reverting to what was the normal schedule, the most recent custodial order in place.
Which was every other weekend.
Yeah, which was every other Saturday morning to Monday morning.
And Judge, what I would indicate is that I'm not sure.
We're trying to reunify. I mean, if you go that far apart, that doesn't sound like he really wants
That's
Well, that's what
Therapeutic.
the normal schedule would be. So
the thing is,
for-
we're not talking about that.
Right,
we're
right, right.
talking about bonding. We're talking about, you're not going to go 2 weeks and then hope to reunify. Really, if you were doing it with a therapist, they'd probably be having you come probably every 2-3 days to work together so that you could bond and reunify.
Your Honor, we are talking about Ethan, right? We're not talking about Nixon.
Yes.
Okay.
So, after, I guess, a weekly reunification of sorts with Ethan, working up to the normal, what the normal schedule was, I just want to...
You could do the first 2 weeks, you could do 1 day for 3 hours on the weekend. And then the next 2 weeks, you could do 2 days in a row, 3 hours. And then that would be tier 1. Then tier 2 could be 6 hours, 1 day, 2 weeks in a row. And then 2 days, 2 weeks in a row. And then I would say, see if he's ready to just go back to seeing his mom on weekends. If he's not willing to go back to that, then I would say do a longer period of time. I mean, try an overnight. Like, try 10 hours with an overnight. Like, go over there at 9 and stay overnight till the next day. You know?
And how many weeks does the court envision of this third party?
Between tier 1 and the end of tier 2 would be about 8 weeks.
But you're looking at having the third party involved that entire 8 weeks, or when do they come off?
For Ethan, I would say he doesn't need one unless he really needs one. If he needs one, he could ask for help. You think he needs one?
Actually, it's not that Ethan needs a third party. It's I go back to the manipulative behavior, past manipulative behavior of the defendant. Really, is what I'm concerned about, is being in his ear and at a very volatile time in their youth. That's my concern. It's not Ethan. I don't. It's her. To be quite honest, I mean, she hasn't shown she can co-parent, or whenever they're over there, she'll say things to him, and comes back, and then Ethan's just confused about things. She's talking about.
What do you mean whenever they're over there? So she's already seeing him?
No, when they've gone over there in the past, before years ago, when they've gone over there, they've come back, very confused about some of the things they get told and some of the actions. I just have a fear of her past actions. She hasn't shown, because we've been in court for 2 years, that she's.
And then one point I wanted to make, Your Honor, about...
Don't you want to start with somebody that's going to be a supervisor that you're going to agree on?
Yeah, that's what yes, Your Honor. I would like to start with the supervised
So
visitation.
there's going to be somebody there.
Yep. Okay.
So my
And when
question
he's
was,
not-
how long do
when
you
he's
envision
not,
that?
when he's comfortable without having to have that person there anymore?
Well,
That's
I apologize. When you say he, who are we referring to now? Because,
Ethan.
well, plaintiff has already indicated Ethan probably doesn't need a supervisor with mom. But it's for plaintiff's comfort level, not Ethan's, is what plaintiff is referring to. And I appreciate plaintiff's comments, but that is all prior to mom undergoing all of the efforts that she's made these last several months regarding her counseling, Judge.
But one point I wanted to make in regards to her counseling is, yes, she's seen Melissa Adams. I have seen one note from Melissa. Melissa is a licensed marriage and family therapist. What Bree Mullins had pointed out in her report was that mom has been taking all of these anti-anxiety, depression medications, and she continues to go see her regular primary care doctor for that, and they recommended her to psychiatry psychologist. I don't know that she is seeing anybody specific for those issues. Yeah, you can go to therapy and you can continue to have your medications filled by your primary care, but the point that Bree Mullins had made in her report was that that's caused these problems all these years because she's probably not on proper medication, or it just hasn't been looked after by the proper professionals.
You mean having somebody look at the anxiety disorder itself and work on those issues instead of having your general practitioner give it to you instead of focusing on like cognitive behavioral stuff.
Correct.
Mom.
I'm actually been utilizing both back in starting in April, correct? And Melissa Adams has been doing what she's doing for 30 years, and she is works with my doctor of osteology, who has taken care of me for 4 years consistently, and they go back and forth. So the therapist is quite aware of what I'm doing, and in one of her letters, it is she also has Dr. Mullins' report as well. The goal is to eventually use tactics to not even have to take medication and go through and just graduate through therapy. So, and
Is it dialectical therapy or cognitive behavioral therapy? What do they call it?
she's doing CBT
Oh, okay.
and working on just to lessen my anxiety, because the times that I have anxiety is really only dealing with being estranged from my children. And so as we work through that, I just work on coping skills, breathing, meditation, to not have anxiety issues over trying to live up to expectations sometimes that are set with no achievable goal by the plaintiff.
Well, I think we should do this, that if the person that you guys agree on as a supervisor, hopefully it'll be that coworker, that person, if they don't have any concerns after the first couple weeks, don't let them have to go, or they can have a check-in, you know what I mean, and say, if the child's not comfortable, let the person keep going. It doesn't have to be that you need to have him there for a 12-year-old. A 12-year-old can make a phone call. He has a cell phone, right?
He does, Your Honor.
Okay, so he'll have his cell phone. The first 2 visits are only going to be 3 hours. The next couple visits are going to be 6 hours. I mean, he can make a call. I'm not really that concerned about that as long as he's feeling strong and he's had supervised a couple times and he doesn't say to you, I'm really uncomfortable, I want the adult to stay there, whatever her name is, Jackie or whatever, then I think he's probably going to be fine. Sometimes kids are like, will you stop this? I need this to start. You know, most of the time it goes like that, like a snowball rolling downhill.
May I make the court aware of something, Your Honor?
Yes.
Briefly? Ethan and Nixon, obviously being brothers, and I haven't experienced it, them being 14 months apart, they are, you know, as brothers do, they kind of combat each other, so I would just kind of like it, not fist fighting per se or anything, but they're at a very volatile time in their relationship, and I'm trying to foster them being good brothers to each other. It's a daily thing that we go through, so I don't want the defendant to, you know, try and push any negatives on. I just hope she fosters the relationship of them being brothers and is positive about that, because I could certainly see in my mind the opposite happening, again, based upon past experience with the defendant. So I just hope that she's aware that she needs to foster that relationship between the two and not try and build a wall between the two.
Why don't you make a list of things that you want to see happen positively? Like, not, don't do this, say, I'd like to see this, I'd like to see that, I'd like you to focus on this, okay?
Great.
Make a list. Not things you don't want to see, but
Right.
you do want to see. Because you get more of whatever you focus on. So make that list. And then no more talking about it after that, okay? Just put that out there, what you'd like her to focus on, the positive things. And she will think about those things. And if they come up naturally, she'll talk about them, right? Okay. And you've got a supervisor who can talk to you guys each about whatever they think that the concerns are. But you're going to come back in 2 weeks and talk to me, so not too much can go wrong in that amount of time. What do we have, Madam Clerk?
March 9th at
That's a little longer
10
than that.
o'clock.
March 9th at 10. All right, so you're going to try to get the financials together by then?
Your Honor, I do apologize. That's a Thursday, and I'll be out of the jurisdiction on that day.
Frank.
You know,
Eee.
Are you here on Tuesday, the 7th?
Tuesday's perfect.
The 7th.
How about you, Amber?
I'm good with that. And then
And if you guys have a stip and you don't want to come in, please just do the stip. But if you
it's
want,
at 9, I'm sorry.
Yes.
And then I did want to ask for clarification. The court is fine with mom's continued medication through her primary care.
Well,
It's
I think that's fine, but I think that they need to talk to each other. You're a therapist and your primary care doctor.
I thought last time you'd indicated that that wasn't okay, and she was to go see someone based on Bree Mullen's recommendations.
I don't remember. I didn't look at that before this hearing today. So you're catching me in a way that I'm not sure.
I ordered the video. I'll review it. I'll bring it to Mr. Tody's attention if that was the
Yeah, you
court's
guys look at
directive.
that and see if you can stipulate to whatever I said last time. Because I didn't review this whole thing. I mean, I've read this whole report before, but I had like 12 things on today.
Yeah, I know.
So I did not have enough time to review everything, just the recommendations and whatever the minutes were from prior hearings on this case. And I just tried to prepare it for what I think we need to go to trial. But I don't think we have to go to trial on this. I think we'll be able to work it out. I'm hoping.
And then one more point about her medication and her doctors, because mom had claimed she's okay, her anxiety just rises when she doesn't see her children. But we've been to court several times over the years because of her actions, and she takes certain medications or doesn't, or she goes off of them. Nobody is just managing too closely what she's taking, and that's where the problems have come in, and that's how we're here in this recent litigation was when she put Nixon into the mental health hospital. So we just want to make sure that she is mentally taking care of herself.
Well, did we ever talk about, I have a few cases like this, but in this case, did we talk about that Dad could have the right to touch base with her doctors and say, is she being compliant? But not get like information, but just, is she being compliant? Is she going to her therapeutic appointments and taking her medicine? I just want to make sure.
If we can have that order, we would like that.
Is she okay with that?
No, I'd rather not. I'd rather just get the letters.
Just let her think about it for the next couple of weeks.
Judge,
I'm not
what Ron
saying he
provided
can.
me, and I'll provide them to counsel.
Pardon?
What you had asked for last time, Judge, was just a letter right before the hearing to let them know that. She actually emailed those to me this morning, so I'll provide those over to counsel, see if that's sufficient.
And one of our questions was what Your Honor just said, that he could maybe call the doctor and get that information. So I'll review that video, and I'll let Frank know if that's what Your Honor said last time, because we would like that order if that.
Right. What I'm suggesting is not, what do you guys talk about? You know, what are you working on? You have a privilege. You're not going to get anything out of therapy if you don't have a place to go where you know we're not going to hear what you're talking about. That's not what I want him to know. I don't want him up in your business. All I want him to know is, are you compliant with therapy? Are you in treatment? Yes, no. Are you missing your sessions? That can make him worried. Are you not missing your sessions? No, she's not missing her sessions. I mean, really, are you compliant is really what he's calling to find out. You can talk to Frank about it, and they might be able to come up with wording that you feel comfortable about. We're not making a decision right now.
So are you okay, Your Honor, with a monthly letter from both doctor and therapist?
That might be something too. I mean, if you want, but you might have to pay for that.
No, I don't. I've gotten one every month since the last time that we had a session.
Really? Well, that's another thing too. Maybe if you're going to get something every month, you wouldn't have to call and you would have something in writing. I mean, there are ways of doing this, and we'll look at whatever it takes to make everyone comfortable. Because I don't think you should have to litigate constantly around this stuff. Obviously not. All right, I'll see you in a little bit.
Thank you, Your Honor.
Thank you.
But she has a therapist. Right. What? No, no.